Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hey everybody, welcome into an all-new episode of Inheritance Solutions for a Diverse Community with Richard Hall, the founder of Bottom Line Lawyers. I am your host, Mike Leon. Richard has combined extensive legal and real estate expertise to help clients with estate planning and to protect their family's future. And joining us in this episode is the paralegal extraordinaire over at the firm, David Pereira. In today's episode, we're going to be talking about why a trust doesn't actually protect your family unless your assets are properly funded into it. Gents, it's good to see you guys as always. Richard, let me start with you on this question here. Why do so many people assume that if they set up a trust, but they never take the next step of transferring assets into the trust? Why do so many people do that?
Well, first of all, thanks, Mike, for having us. Appreciate that. Good seeing you again. It's a very common thing where people actually walk out of the attorney's office and say, well, I got my trust, everything should be good. But unfortunately, not all attorneys actually properly fund the trust. And fund only means that you've got some asset that's in it that makes the trust valid. Most typically, for most folks, the asset that has to be put into the trust is the home. And it's a unique thing because real estate has to specifically be deeded into the property. And everyone assumes that the attorney took care of that, and that's not always the case. And so it's always good to check and see. And the way to validate that is you can actually look at your own grant deed for your home and say, does it say, Mike, hereby grant to Mike as trustee of the Mike Trust, this property. If it says that, you're good to go. If it just says it's a grant deed to Mike, you have a problem.
Well, I love the name of the trust already. So, David, let me ask you, what does trust funding actually mean? Can you explain it for the audience?
In real simple terms, it's really about who actually owns the asset. So when you look at individually, we understand how we all own it, but now you have this trust set up. That ownership is a little different. A trust can't own property by itself, but the trustee of that trust does. And so you typically need to transfer that asset into the name of the trustee as trustee of that trust. And that's how you get those assets in there. If you don't put them into the trust, well, then they're just not in there and they're not going to be distributed the way you wanted in the trust.
I mentioned in the intro about real estate and the work you do there, Richard. So let me ask you, because I'm sure the real estate part of this causes a lot of confusion. What should the California homeowners out there that are listening to this understand about transferring their home into a trust correctly?
So first of all, they should be clear they don't never lose control of their real estate. If it's a revocable trust, they're always in charge. We're just changing it so that it will get the benefit of the trust, including the stepped up basis. But what they need to do is very simple. It needs to be a grant deed that, as I mentioned earlier, that is, from Mike to Mike as trustee of Mike's Trust. It needs to be properly notarized. It needs to be recorded with the county recorder. And that is what really makes that property be part of the trust. And that's sufficient. But a lot of people don't do that, or a lot of attorneys don't follow through on that. The other area where it gets messed up a lot, we had one recently where a property gets refinanced and escrow, the lender's going to say, you've got to have it in the name, your name, not in the name of the trust, or we won't finance. Fine. So escrow takes it out and puts it back in your name. That's fine. But after the transaction is complete, they don't put it back into the trust name. We had one recently where the escrow put it in. They had two assessor's parcel numbers. One of them went back in the trust and the other one didn't. It was a mess. We fixed it, but it was a mess.
David, let me pivot to bank accounts and investment accounts, and they all have different rules. What tends to surprise prospective clients when they come in? They ask about how these financial institutions handle title changes for a trust.
Well, what I like to always say is, he who has the gold makes the rules, right? That's the golden rule. So it's going to vary by institutions, quite honestly. And what's important about that is you need to complete their paperwork in order to make that happen. And that's generally something that the individual has to do because even if you have a trust prepared at a law office, the office can't call that bank or that investment firm and say, "Hey, we want you to change title on this particular account to the trust." That has to be done by the individuals. So that's something that gets overlooked and you have to be careful about. And it becomes really essential when you have situations that involve what we call supplemental needs type of persons that are either currently in the trust or who may inherit. And so having those things done properly becomes really essential for that to make sure they get taken care of. And that's a complex issue, but it shows you the level of importance that you have to pay attention to these things.
Richard, let me ask you, and let's pivot to beneficiary designations. I know that those can override a trust entirely sometimes. So how have you guys helped clients make sure that things like life insurance, the retirement accounts I just mentioned a second ago, that they actually line up with the estate plan?
So you're right, all of those things need to be changed. And sometimes we have the beneficiary changed to the trust. In other words, we want the money from the IRA, the 401k, the annuity, whatever it may be, to go into the trust. And then that's fine. But if you don't want it to go to the trust and want it to go directly to a beneficiary, we need to make sure that that is named, that beneficiary is properly named with the institution that actually holds that particular instrument. Uh, so we check that, and we recommend usually for some assets. I'm not even going to say usually. It depends. Some things should be have the trust as a beneficiary, and some should go directly to a recipient.
David, we're always trying to avoid the P word. That's probate for a lot of people out there that are uninitiated to this. What happens for people listening out there? What happens during probate if someone thought their trust it covered everything, but there were maybe one or two major assets that were never moved into it?
Yeah, it can get kind of complicated. One thing's for sure, it's going to cost you more money because it's going to require a court intervention of some type, depending on whether it was clear or not. There's a thing, what we call a Hegstead type of petition, where you can take care of those kinds of things. It's a more quicker approach, but it's still complicated. And, ideally, you don't want to have that situation. You don't want to leave it out because it just opens up more complexity and time. Anytime you have to go to court, time becomes a big factor. And so, you know, you can still avoid probate in a lot of cases, uh, but also I want to throw into this. That's why there's other documents that are done as part of a typical trust beyond just the trust document itself. And that becomes real critical because there are things like a pour over will and an assignment of personal property that comes into play.
Yeah, in California, I would add that new legislation has empowered a different kind of probate, but our experience of it thus far is that it's pretty ineffective. The idea is that an estate below a certain amount of money can go through a simpler probate and go through more quickly, but there are some gotchas. So if somebody's inclined to do that, I would still urge them to consult with an attorney before they go down that path. And then there's another level of estate where it is essentially under 180,000 or so, and you can cover it with a small estate affidavit as long as there's no real estate involved.
Well, Richard, let me ask you because we were just talking about things that people forget to put in these trusts. From your experience, what have been some of the most common assets that you've seen people forget to fund inside the trust, ones that maybe accidentally end up outside of it?
Well, the one thing, as I mentioned, about a home after a refinance, that happens more often than I'd like to think about. People don't put it back in the trust. And then there's some odd assets that people don't remember. For instance, mineral rights might be an element, or an old stock certificate. Almost no one has physical stock certificates anymore. But if you bought stock years ago, you still have a certificate. They haven't put that in. One of the things that we do to help cover that is we do an assignment of assets in preparation of an estate plan. And we didn't talk about it, maybe we should, that there are 5 really key elements to an estate plan, not just the trust. And some of them I think we'll get to that are even as important as the trust itself.
David, let me ask you, can you walk us through what a proper trust review looks like when everyone's double checking the titles, the deeds, the designations, making sure that everything matches? Walk us through it.
Yeah, so a lot of times what we'll do is we'll pull property records to see what's the last deed recorded on the property to kind of see how title was held. That becomes essential. You'd be shocked at the number of people have no idea. And we'll even see things that there's other people on title that maybe shouldn't be, or someone's passed away. So that becomes essential. Then we double check to make sure that deeds that they did prepare were actually ever even recorded themselves. So let's say you did an estate plan and you did a deed to record a house, but if you never recorded it, well, nobody knows about it. So those will be things that we'll look at, and assessors records, and and then we generally will ask them to look at all their bank account records, brokerage records, IRAs, KEOs, retirement plans, all of those kinds of things, and make sure that they have it all set up right.
As we wrap on this episode, Richard, let me ask you, for someone who's listening to this episode, they already have a trust in place. Now they've heard you guys speak. They're not confident that it's funded correctly. What's the best way that they can get some clarity on this before anything goes wrong?
Well, the first order of priority would be to actually match up what they have in their trust with other documents that they have. They're in possession of those documents if they have an annuity, if they have mineral rights, if they have any other kind of asset, and they should make sure that those things are referred to in the trust or in an assignment. But failing that, or if they want a higher level of confidence in what's in the trust, then I would suggest a review by an attorney. But I will tell you, a lot of folks will say, well, I want to do a review, which ends up being more expensive to do than actually doing a restatement of the trust. And the reason for that is if an attorney takes on the role of reviewing the trust, they need to review everything about it, all the legal aspects, make sure that the law that's cited is still correct and all that, which can be very time consuming, versus doing a restatement, which is, as the name implies, restating the existing trust, but making sure that all of the new laws apply is a better way to go about it. So first off, review for yourself. Second of all, ask for an attorney. But if you're going to do that, seriously consider a restatement, because the laws do change.
Yeah. Gentlemen, thank you for the time and insights on this topic. I truly appreciate it, guys.
Yeah. Thank you, Mike. Appreciate it.
Thank you, Mike.
And thank you to everyone out there for listening to this installment of Inheritance Solutions for a Diverse Community. If you want to learn more about the work that Richard and David and the team do over at Bottom Line Lawyers, do me a favor right now, visit bottomlinelawyers.com. Don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.